How's it going, everybody, and welcome back to Lead Therapy, and thank you so very much for taking time for tuning into the video. It seems lately we're always talking about either New Jersey, New York, or California when it comes to new gun control laws. And this is coming out of California. California advertising ban targets the First and Second Amendments. Anti-gun politicians hate civilian gun ownership so much they're willing to do away with the First Amendment to get at the Second Amendment. Such is the case with New York's new speech-based restrictions on the right to carry. Just as troubling is California's AB 2571, which purports to ban all firearms-related advertising that a minor, those under age 18, might find attractive. Signed into law by Governor Gavin Newsom on June 30th, AB 2571 provides a firearm industry member shall not advertise, market, or arrange for placement of an advertising, marketing, communication concerning any firearm-related product in a manner that reasonably appears to be attractive to minors. Note that the advertisement need not be aimed at minors. The item only needs to appear to be attractive to minors in order to trigger the ban. The legislative text goes on to list some examples of what would constitute prohibited marketing. However, the statute makes clear that the prohibited advertising is not limited to these examples. This means that there is no way to determine what a given California court might find as appearing to be attractive to minors, and thus banned. Of course, a great deal of advertising is attractive to both adults and minors. A young shooter or hunter might value the same characteristics in a firearm-related product: accuracy, reliability, ease of use, that would attract an adult buyer. Therefore, the legislation invites endless litigation over the contours of the prohibition. According to the statute, an advertisement is explicitly prohibited when it offers firearm-related products in sizes, color, or designs that are specifically designed to be used by or appeal to minors, uses images or depictions of minors in advertising and marketing materials to depict the use of firearm-related products. Note that this prohibition would not only eliminate advertisements supposedly targeted to minors, but also encompasses advertisements informing parents about lawful products they might purchase to use with their children. This would include a ban on advertisements for youth versions and sizes of common sporting rifles, shotguns, and stocks, and could be read to involve advertisements involving size-adjustable stocks and accessories. Moreover, the law bans any depiction of a minor in firearm-related marketing materials, no matter the context, as a love for the shooting and outdoor sports is often passed down generation to generation. Wholesome family-centric shooting and hunting imagery has long been a staple of firearms advertising. Such artistic representation of the shooting sports are prohibited under this legislation. A firearm industry member that disobeys California's speech restrictions is subject to a penalty of up to $25,000 per violation. The legislation makes clear that each copy or republication of marketing and advertising prohibited by this section shall be deemed a separate violation. The bill also invites attorneys to inundate the firearms industry with lawsuits by creating a private right of action against offenders and offering those who prevail attorneys' fees. Given California's political posture in the wake of the U.S. Supreme Court landmark New York State Rifle and Pistol Association versus Bruin decision, and the expansive scope of AB 2571's ill-defined speech restrictions has no relation to their purported goal, it's likely the law drafters of protecting children. Rather, the legislation is written in a manner so broad as to attempt to eliminate firearm advertising in the Golden State, and in turn pro-Second Amendment publications that rely on firearm advertising for revenue. The bill's supporters' overarching goal is to stifle their opponents' political speech. However, even if AB 2571's drafters' motives are taken at face value, the legislation violates the First Amendment because it is overbroad in a content-based restriction on speech, and even if analyzed as covering purely commercial speech, fails to comport with the Supreme Court's existing commercial speech framework. In addition to violating the First Amendment, the law likely violates the Equal Protection Clause. While the law would prevent members of the firearm industry from engaging in certain speech, it would not prohibit others from engaging in the same conduct. Under the Supreme Court's test laid out in the Bruin case, the law also violates the Second Amendment. Justice Thomas' majority opinion makes clear that the burden is on the state to defend any restrictions on the right to arms by showing that the regulation is of a type or analogous to a restriction, has historically existed on the right since the founding. Such broad bans on the advertising of Second Amendment protected services and products clearly have no historical analog. There are already multiple challenges to AB 2571 underway, and hopefully soon they can get this ridiculous law overturned. As always, let me know your thoughts about the story in the comments section down below. And if you enjoyed the video, or if I gave you some information you didn't know, please take time to like, share, and subscribe and hit those post notifications. It would be greatly appreciated. And I will see you guys in the next video.